I am a partner at Keoghs Solicitors. We are a defendant insurance law firm, so I do a lot of claims involving fires that we saw in the last session. So my expertise is in the construction and electrical sectors, and I've been working with ECIC, part of Markel, for almost 10 years. We've got quite a lot of heavy litigation going on at the moment. A bit about my firm. We have 7 offices currently, 1,700 staff and continuing to grow, and we just do defendant insurance litigation, so only act for insurers and their policy holders. So I just thought I'd do a bit of a back to basics before we go into this case of haberdashers, which has changed the law on project policies. So as everybody knows, it's essential to have insurance for any construction contract. It protects all the parties to a contract, and it's essentially got special rules that apply to insurance contracts that don't apply to any other types of contracts. So you've got to keep an eye on the special conditions, especially with regards to hot works, because they have got quite strict conditions. So what are project policies? It's really quite straightforward. It's an insurance policy that sits at the top of any construction project. The idea is you have one policy that sits at the top and covers all the different parties to that construction contract. And they can be bespoke to whatever type of contracts are involved. The main thing about a project policy is the idea is the insurer who sits at the top, who is the project policy insurer, then cannot sue any of the other parties down the chain. So the idea is, as it says in the middle, the insurer waives its right of subrogation against the insured parties. So essentially, if the party at the bottom of the chain is responsible for a fire or whatever has happened and it's covered under the project policy insurer will cover that and cannot sue against any of the other parties down the chain. So obviously that's got to be a good thing. There are benefits to that. So in theory, all parties should benefit because it avoids gaps in insurance policy. So if you had 5 or 6 parties to a contract and they all had different insurance in place at different levels, there could be gaps. So one insurance at the top that covers everybody avoids that. It keeps costs down, so rather than having lots of different policies, there is one in place, and it's easy to use, one policy. And it's meant to reduce disputes because essentially it's not pointing the finger of blame at anybody because it's all covered by the project insurer at the top. This is essentially what you should get from your project insurance, which I think is a pretty robust defence. However, things have changed a little bit in this case of haberdashers, and I don't know how many of you are aware of it. I'm sure most of you have heard about it, but it involved a fire at a school, and the judgment, which was in the High Court before Mr. Justice Fraser, talked about project insurance policies and how it affected the parties lower down the chain. I'm not going to go through this, but this is part of the judgment about how the judge saw project policies protecting all of the parties. I thought this was quite helpful just to talk through all the parties that were involved in this case. So haberdashers at the very top is the trust that owns and operates quite a few schools. The school involved was in Lewisham, but the council actually owned the property that the school occupied. So there was an agreement between haberdashers and the local authority that they would carry out some development works to the school in Lewisham. The council then engaged LEP, who had to have project insurance in place to cover the whole construction contract. LEP then engaged Lake House, who were considered the main contractor, so they were carrying out refurbishment works and extension works to the school. The main contractor then engaged some different specialist contractors, including CPR, who are a roofing subcontractor. So they engaged them to do the specialist hot works on the roof. This was in 2009 and 2010. Then in about April 2010, whilst doing some hot works, CPR left some, like we saw in the last session, some torches, blow torches that they were using on the roof. So unfortunately, fire started, spread considerably throughout the school, causing serious damage. So the council and haberdashers blamed both the main contractor and the roofing contractor for the £8.75 million worth of damage. So essentially, these were the legal claims. The council claimed against the main contractor. The main contractor said, well, if I'm liable, so is the roofing contractor. The main contractor settled with haberdashers and Lewisham Council for £8.75 million under the project insurance. So you would think that was the end of it, but because the main contractor had their claim against the subcontractor, the project policy insurer wanted to see if they could recover any of their £8.75 million. The subcontractor, roofing contractor, had its own policy in place for £5 million. That was the limit of indemnity. So that's what the main contractor was pursuing them for, £5 million, not the full £8.75 million. So it became a real battle between the project insurer and the insurer of the roofing contractor. So the roofing contractor argued, you can't sue me. I've got benefit of the project insurance, which sits at the top of this construction chain, and you are barred from suing me because you're not allowed to do it. That's the benefit of project insurance. That's why I've got project insurance. The main contractor agreed, yes, that is right, and you would ordinarily be covered, but there was a separate subcontract between the main contractor and the subcontractor, and there was an express term within that contract that said they must have their own insurance. And because the subcontractor had their own insurance, it was deemed that actually that was overriding the defence that the project insurers had, and that they then could sue them or seek to recover against them. So the express terms in that subcontract agreement between the main contractor and the roofing contractor are key. And that's really what I wanted to talk to you about today. The judge, Mr. Justice Fraser, he looked at different legal principles to get to the answer, and I'm just going to whiz through those because it's a bit heavy for a Friday afternoon. But essentially, he dismissed acceptance by conduct. He wasn't quite sure if the main contractor acted as an agent of the subcontractor, but what he did say was the right legal principle was standing offer. So, i.e., when the project insurers had in place cover for all the subcontractors, and then the subcontractors entered into their own subcontract, that was essentially an offer and acceptance. So he agreed that the subcontractors could have benefit of the project insurance. Let's whiz through that one as well. So what effectively then happened was the main contractor's case against the subcontractor was successful because of this express condition that was in their own subcontract agreement. So essentially, that was overriding anything else, and that was the Lord Justice Fraser said that on that basis the main contractor was entitled to recover the £5 million. So, and the subcontractor wasn't entitled to rely on the project insurance, which he thought he had the benefit of. So really, what is the impact of this decision? Well, it's quite a big decision because actually, for years, everybody's been relying on the benefit of project insurance, but the terms of your own insurance further down the contractual chain actually has a big impact on whether you can rely on the project policy that sits at the top. So this is actually very interesting, and it was a decision that came out earlier in the year, and there has been no decisions that challenge it yet. So it stands as good law. Is it right? There has been a lot of debate that actually, no, it's not right. And I personally prefer Ant with Deck, so I'm saying it's not right. So some people disagree. In fact, I know Mark disagrees. So what are the issues arising from this? Well, it's the government who've been pushing project policy insurance for large-scale projects. And this judgment highlights actually that there's now a gap, and this isn't actually giving the protection to all these contractors that it should do. So it raises questions as to what cover you've actually got in place when you're engaging in any contracts, and the limit of indemnity, for example. So I think this is one of the issues. The main contractor only sued the roofing contractor for 5 million. If he had sued him for the full 8.75 million, what would have happened to the rest where he wasn't covered? Would that then have been covered under the project policy? But that doesn't make sense. So there are quite a lot of questions that arise from this judgment. So what does it mean for contractors? Obviously, for project insurers who sit at the very top of the chain, this is good news, because they now know that if there are separate express provisions further down the chain, they can actually overcome this defence where they can't recover from any of the insurers. But this is not good news for subcontractors, because you go into any contract thinking you've got the benefit of project policy, and in fact you may not when you don't realise that you haven't. So what to look out for? It's really important to consider your own PL insurance, and when you enter into any contract, how that might negate any benefit you may get under the project insurance. If it's the intention of the subcontractor to be a joint insured under the project insurance, then the subcontract shouldn't have any overlapping obligations. So that means you shouldn't have any you shouldn't have your own insurance that would then override the public liability insurance, but it depends on each individual case. So to get over that, it's very important and sensible before you enter into any contract that you know what insurance is in place at the top of the chain, and what insurance that you need to have as a consequence of that. So it's good to get that in writing so that you are quite clear. So the other thing that's really important that didn't happen in haberdashers. In haberdashers, the project insurance policy listed that it would cover all subcontractors of the main contractor of Lake House, but it didn't actually name them. It just said all subcontractors. So one thing to make sure is if you're relying on project insurance policy, that you have your actual name in the policy, so that that's the starting point. And then secondly, if you have to get any of your own insurance, then you need to just pay greater attention as to make sure that that doesn't override the project insurance. So looking to the future, this case has been a huge decision because the effectiveness of project policies is now uncertain. There are lots of concerns regarding this decision, especially for contractors and insurers, as to what protection is in place. But each case is very different, so you must look at the facts of each case. The terms of each insurance policy need to be considered carefully. But I think the most important thing is don't assume because there's a project insurance policy in place that it will protect you, even if you are a co-insured, because as we saw in haberdashers, the roofing contractor was not covered at first instance. If there's any concerns, your broker should be able to point you in the right direction. So the roofing contractor is not very happy, as you can imagine, or its insurer with this decision. So it is being appealed at the beginning of next year. So there's quite a lot to watch out for because they will be obviously trying to get that decision reversed. And that's essentially it.